And here we go. Another high-stakes courtroom showdown. Pay attention. This one's about custody, credibility, and some very serious allegations.
Good afternoon, Your Honor. Ellen Michaels on behalf of James Worthington. My P number is 67943. Mr. Worthington is present in court.
All right. Your name, sir?
James Worthington.
All right. Very good. All right.
So today's the date time set for our second probable cause conference. We'd adjourned it in order to get all the Child Advocacy Center videos. I'm short 2 videos, though I've been notified that they have been sent to me. So I believe we're ready to set it for exam, assuming that they in fact were uploaded today as stated by the prosecutor.
For clarification purposes, I have confirmation from the detective, the officer in charge, that they have just as of today been shared and made available on evidence.com. I've relayed that information to the proper individual in our office. I would expect that those will still be shared with counsel before the day is over. But just to be clear for the record.
All right. And if those are done, then discovery is complete.
Yes.
Yes.
Don't like to do it this way, but I get what you're saying, that it's there.
Understood, Your Honor. Thank you.
If there is a problem, I will bring it to the court's attention and file the appropriate stipulated motion in order.
Right. But that's what we try to give people time at PCC to get all that stuff straight and not set something and then have it adjourn out. So
Understood.
I want to make sure that we're going to be able to go forward. People had their witnesses available the 28th
28th of
January.
what time?
9 a.m.
Oh, I'm not available at all that day. I have a 9 a.m. exam and a 12:30 sentencing.
February 4th
Checking.
or February 11th.
What time? February 4th, 9 a.m.
No, you're all at 9 a.m.
February 11th. February 11th is good.
Preliminary examination in person, February 11th, 2025, 9 a.m. before. Judge Valvo. Am I ahead on that list? Okay. Before Judge Valvo.
I didn't hear the name. What name?
Valvo,
Thank you.
bond will continue.
I'm asking Your Honor to again revisit the bond conditions. What I'm simply asking is that my client be reunited with his children. He does not need to go back to the residence that's across the street from where the complainant lives. The family can stay with a friend in a separate location, but since the incident that the 2 children of my client have been taken away, even though CPS has not filed the case is.
Whoa, the defense is asking for bond conditions to be changed so the father can reunite with his kids. But here's the catch. In cases involving allegations against minors, judges almost always play it safe. Think about it. Would you take the risk of sending kids back if there's even a shred of danger?
Been closed, there's no issues. The children are staying with grandparents, and this has been going on since early December.
Your Honor, people continue to object to that. Again, as I indicated the last time you were here with the same request, I get that. I really do. I'm not comfortable agreeing to that because although I understand that defendant's daughter was interviewed at the CAC and did not disclose, that being said, our charged victim, her first trial best friend, in her CAC interview, where she made all of her disclosures, she indicated that his daughter also told her that she had been sexually assaulted, both by defendant and by their son, as well. So I am concerned. I'm not willing.
This is huge. The prosecution is leaning on testimony not just from the alleged victim, but from her best friend. That kind of secondary disclosure can weigh heavily with a jury. Emotional testimony, especially from kids, often hits harder than hard evidence.
We're able to agree to change those bond conditions. Understanding, obviously, ultimately it's up to the court. But I am concerned for the safety of any minor child.
And I'm quite frankly, counsel, I'm in the same position I was the last time, I think, that I don't think anything's changed, and I denied the request the last time, and I don't have any additional information that would lead me in that other direction. So I'm going to decline. I'm not going to change its bond conditions.
Can I just make a record on one matter?
Sure.
Thank you so much. My client's daughter, Lila, who the prosecutor was talking about, she was taken by the police to University of Michigan Hospital and physically examined. There's no indication of any sexual assault. She was also, as stated, interviewed in a forensic setting and did not make any disclosures. We believe this is all part of these are all false allegations, and the children, there's no evidence that his children have been assaulted in any way. This is part of the discovery that was tendered to me by the prosecutor, the medical records and her interview.
Judge, as I indicated last time, same record was made then, same arguments were made then.
I know.
Certainly the court has been doing this as long as I have been doing this. There aren't hardly ever medical findings when a small child has been sexually assaulted. It's all about timing. It's all about type of sexual assault. It's all about those areas of our bodies being fast healing. It's all about so many moving parts that a lack of medical information means zero things in terms of whether or not a child has been sexually assaulted.
One more thing, Judge, that the allegations are that the daughter allegedly said that my client penetrated her every single day. There would certainly be medical evidence of that. Thank you.
Notice the clash here. The defense argues that daily abuse would leave clear medical evidence, but the judge counters with a crucial legal insight. Many assaults leave no visible trace. This back and forth highlights just how messy and heartbreaking these cases are.
It would not necessarily be. Penetration can be a whole lot of things with a whole lot of things.
Yes. And again, I know you made your record, but I'm still at this point going to deny that. Judge Valvo, after the damn happens, may feel differently, and certainly you can bring that before her. But at this time, I'm going to deny the request. Bond will continue.
Thank you very much.
Thank you.
Thank you.
How's the case of People versus Christopher Jordan?
Actually, one of the people.
Judge, EA 4261 here on behalf of the
All right.
who is not present.
Who's not present? Okay.
I was wondering maybe we could do this without him.
Not for long, we can't.
Your Honor, I know the court has received the
Violation.
bond violation report from community corrections indicating that no tests from therapeutic.
And just like that, the gavel comes down. A $25,000 cash bond for failure to appear. Judges don't mess around when defendants ghost court dates, even if they have excuses like homelessness or illness. What do you think? Tough but fair, or too harsh?
Have been sent over, and defense counsel was kind enough to provide correspondence from therapeutics dated yesterday, indicating that the defendant had been doing some meetings and some other things with therapeutics. But as I looked through that paperwork, I wasn't able to see a record of any drug testing. So I'm not sure if I missed something. It's certainly possible, but I didn't see anything in that correspondence that had that in there.
It's sorry to interrupt. It's on the top of.
I didn't see.
On the top of the second page, client is in phase 1. He provides UDS, urinary drug sample.
It doesn't include testing results.
Yeah, that's right. I figured there would be some testing component to it, but I don't know where are the results of those tests?
I don't have the results of the tests. Therapeutics, I understand, is doing the testing and continuing to provide Mr. Jordan with the methadone that he is part of his treatment.
Okay, but are they sending the test to our community corrections?
Unfortunately, it seems that they are not. So I don't have the results, but I do have record that Mr. Jordan is in treatment. He is living homeless, as I was explaining to opposing counsel. He's availed himself of a lot of resources here. There are two volunteer social workers from the warming center that asked me to step into the case. I'm on this case pro bono. So Mr. Jordan is in treatment, and I apologize to the court that I don't have the records of the drug, the sort of results of the drug testing, but he's availing himself of treatment. He's in, he's attending these meetings, both individual counseling sessions and group meetings. And the other thing that I think is relevant to the court is Mr. Jordan, this is a case from 2022, 2.5 years ago. And there's a more recent case. He was charged with a misdemeanor, and we resolved that last year with the prosecutor's office dismissing the case pursuant to Mr. Jordan being in treatment, which he's still in treatment. And so it feels a little counterintuitive that we dismissed a more recent case for Mr. Jordan's compliance with treatment, which he's remaining in compliance with. And we've now charged him with a felony from 2.5 years ago. I'd ask the court.
So you should say the prosecutor should not do that kind of thing where, I mean, if they've got to be intuitive, that means everybody should get charged and just go for it. Never mind. Go ahead.
I'm asking that the court, because this case also involves an extremely questionable stop by the police and search of Mr. Jordan as he's walking down the street or jogging down the street. I'm asking that the court, before a warrant is issued on such an old case where there is a questionable, there is, I argue, a Fourth Amendment violation.
Okay, I get that. If he got here, then we could have the hearing on all of that.
Yes.
But he's not here.
Understand. He's ill. He's living homeless. It's been extremely cold outside. He's managed to continue to get himself into treatment. So I'm just asking that the court hold off on a warrant and allow us to litigate the legitimacy of this arrest without a warrant issuing.
Well, I'm going to issue a bench warrant for his failure to appear at this proceeding. And I mean, I might not do that if I had test results coming in, given the circumstances, but I really, none of this really puts a picture together for me of where the defendant is or what he's doing, and certainly not testing. So I'm going to issue a bench warrant. Bond will be set in the amount of $25,000 cash surety. If you locate him and can get him in, there's a warrant recall procedure you can go through on this. That warrant will issue immediately. Thank you. Oh, you did another. Got it. Okay. Because I finished up these other. All right. Court calls the case of People versus Tournier 2440331.
Taylor's on behalf of the people.
Good afternoon, Your Honor. Charlotte Stephan on behalf of Mr. Tournier.
Okay.
Mr. Tournier.
All right. So what we've done, this is on the case that was before Judge Freshour. Bench warrant was issued. I'm going to recall the bench warrant on that. He's spoken with Judge Freshour's chambers. I will reset his hearing to January 30th, 2025 at 9 a.m. before Judge Freshour. I'm setting aside the warrant, but he must test with community corrections. He probably can't make it today. Well, maybe he'll still get in today. I think they close at 4:30. Okay, sorry. So I'll have to come back another day.
I'll do it tomorrow.
But we got your warrant set aside.
I do have a question.
And
A lighter moment in court. Even the judge cracks a bit of humor here about the cost of drug testing. But notice the subtext. Compliance isn't optional. Miss a test and you're right back in legal hot water.
What I also did is we checked with Judge Freshour. The oral testing is also appropriate or is sufficient in this case so that we don't have to go through all of that.
Thank you, Judge.
Yes, sir.
Is it costly? The mouth swab.
There will be a cost to it.
I just need to know how much so I can figure it out by tomorrow.
Do you know how much the oral testing is? Anybody?
Sorry?
Oral testing at community corrections? Yeah,
30, somewhere in there, I think.
yeah, it's more
It's
expensive
more expensive test.
than the urine test. All right, here's what you do. Get yourself done. You got to do that within 24 hours. Okay, so get that money together, get down here tomorrow if you can and get a test done.
Sir.
Okay, and get the first one in and then try to work it through as to how you're going to do each one per week. Okay.
All right.
All right, but make sure to get that one in so it doesn't look like you're just avoiding it.
Sir.
It's $20. Okay,
Thank you, Your Honor.
you're welcome, sir.
Thank you, Judge.
You're welcome. Oh, he's not here. Court does call the cases of the people versus Alan Maloney. On these cases, Mr. Stringer is not here. Mr. Stringer did contact our office.
Yes, Your Honor, he contacted me as well, and I'm aware of his difficulties today.
Yes,
And I
okay.
just told him that to not be concerned with this hearing, I would request a new date on his behalf and now I understand his client is not here.
Yes. So I don't know how long. All right, let me adjourn it out a couple weeks. Okay. So probable cause conference, January 30th, 2025, 9 a.m. or sure in as the invite indicates. Bond will continue.
Did it 1 week, Your Honor?
Two,
Two, thank
I
you.
did the 30th.